Again, welcome everyone. Thank you to come to this webinar. I know everyone is busy, so appreciate your time. This webinar is all about family trust. In New Zealand, family trust is a very popular way of, protecting your valuable assets. And when we work with the clients to finance their properties, we get asked a lot by clients in terms of, should I have a trust or not? So that's why we want to set up this session just to help you answer some of the basic questions about family trust, like what is the trust and who should have a trust, and how can you benefit from that? And also, once the trust is set up, what are the maintenance involves, and how much is the cost, and who involved, etc. So we'll cover everything in today's session. Now, let's do a small exercise. So there's a poll here. If you like to participate, so there's a question at the bottom of the screen. So we have a question for you. Do you have existing trust? Please feel free to answer so we know what the audience understanding about the trust. Okay, sorry, the polling is just launched, so please feel free to go to that poll and give the answer, please. We have about 80% of people already voted, so about 23 already having a trust, and 50% of us has not got a trust, but has been thinking about having one. So that's good, because this is a session it's going to be really helpful for you to make a decision. Great. We'll come back to that poll later. We're almost there, so about 88% voted. Excellent, thank you so much. Okay, so today we have our special guest, Samuel Ames. Now, Samuel is the associate from Turner Hopkins. He has experience in a broad range of private client matters, including but not limited to estate planning, trust structuring, relationship property, retirement village, and estate administration. He has a particular interest in charitable organizations and incorporated societies. Samuel enjoyed getting to know and understand clients and providing tailored practical advice with the aim of bringing clients peace of mind, knowing their legal affairs are in order. Samuel has presented for Auckland District Law Society and New Zealand Law Society, and is a member of ADLS Trustee Committee. Okay, that's enough from me. So now I'll pass over to our expert presenter, Samuel Ames. My colleague Stephanie is also standing by from our team, just in case there's technology failure, and she'll also help me manage any question. If you have any question, please tap into the Q&A box, and Samuel will answer them in the end. Okay, over to you, Samuel. Thank you for joining us for this presentation this afternoon. Samuel, can you hear me?
I can hear you, and thank you very much, Connie, for your introduction, and also thank you to you and your team at Prosperity Finance for the opportunity to present today. We really appreciate the opportunity and look forward to being of service and providing your clients with some information. This is a free webinar called Trusts 101, and it's an introduction to trusts, and I welcome everyone here. According to the poll, it looks like we've got about a good mix of people who have trusts and some people who don't have trusts, and are people who are thinking about trusts. So hopefully you all have something to learn and are able to benefit from this webinar. As Connie mentioned, I'm a solicitor at Turner Hopkins, and we are a full-service law firm that provide advice in all the key areas of law, including property, commercial property, litigation, and we have a large experience in estate planning, which includes trusts and relationship property and wills and estates. So we very much enjoy helping our clients achieve their goals, and our firm motto is that we care, and we take special pride and attention in looking after our clients' needs and providing the best possible service. I've been at Turner Hopkins for about 1.5 years, and the team is great, and the firm is an excellent firm to be a part of, and we look forward to serving clients all the time. So to begin with this webinar, I thought we would just cover off what we're going to talk about. If I can get to the next slide. So the things we're going to cover today will be what is a trust and how does that work? And once we've answered that question, we can look at what a trust does and how it can benefit having a trust. And then we'll look at the importance of maintaining a trust and keeping it running properly and smoothly. And we'll also cover off some of the drawbacks or pitfalls with trusts to be aware of, so that we are fully aware of what a trust is and what it involves long term. Okay, so the first question is, what is a trust? Well, in this webinar, we're talking about family trusts. And family trusts are usually what happens when you have a husband and wife or a partner, two couples, and they create a trust for the benefit of themselves and for their children. And all those people are often called beneficiaries, and so they create a trust to hold their family assets, things that they've saved up for during their lifetimes and own for the benefit of all the family. We won't be talking about charitable trusts or other types of trusts, but this is the common family trust, which is also known as a discretionary trust. Trusts go back a long way, and they originated way back in the 12th and 13th centuries in England. So they have a strong historical background, and started when kings and knights would go charging off into battle, and not sure if they'd come back home alive, they handed over their assets to someone that they trusted to hold on behalf of them for the benefit of their children and their wives and partners, so that if they didn't return, they knew that the assets would be looked after and not wasted. Otherwise, if they didn't, then they'd have no control over their assets and they could lose them if they die. Some say that things haven't really changed very much, and that trusts are there to protect assets and provide for future generations and avoid people coming into trouble and wasting their assets. The best way to understand a trust is to think of it as a set of relationships, a bit like a triangle, where you have one person at the top, one person on the bottom corner, and the other person on the other corner of the triangle, all working together. And this is a legal relationship between three parties. One is called a settlor, one is called a trustee, and one is called a beneficiary. And we will talk about what those mean shortly. A trust is also an asset owning vehicle. And to answer the question, what is a trust, we have to look at what is the purpose of a trust. And so trusts hold assets and protect them for future generations. The question is, what assets do you want to protect, and why are you protecting them? And normally a trust will own assets that are of value and are appreciating. So this will include a house. It could include money in the bank, so a bank account in the name of the trust. It could include company shares. It could include investments. And it could include even life insurance policies, so that when the person dies, the money goes to the trust. Another function of a trust, in terms of what it does, is that it keeps assets hidden. There's no register for trusts, unlike companies on the Companies Office, and so nobody knows how many trusts there really are, or what they're called, or what they own, or who controls them. So in a sense, if you have a trust with assets, it can keep assets private from other people, and there's no obligation on you to disclose what those assets are, generally speaking. Also, what is important to consider is the concept of trust itself. A trust is called a trust because there needs to be trust involved to make it work. And the function of that is to ensure that you have people who are trustworthy looking after the trust. Those are the trustees. It's important to understand what trust means in this legal context, which we will come to when we talk about trustees. So the next question is, who are these people involved in a family trust? Well, the players in a family trust, as I said, are the settlor, the trustee, and the beneficiary. The person who is the settlor is generally the person who creates the trust. In our example of mum and dad who have settled a family trust, the settlors are usually the mother and the father, or the husband and the wife, who create the trust by signing what's called a deed of trust. The deed of trust is a fairly lengthy document which sets out who the trustees are, who the beneficiaries are, and what the powers of the trustees are, and what the trustees can do in management of the trust. It also includes how the trust can be dissolved and moved onto another trust, and how it can be amended. All trusts are a bit different, depending on the deed of trust. So the settlor is the person who signs the trust deed and creates the trust. The settlor is also the person that transfers assets into the trust, usually their own assets, or assets they've acquired. The settlor can also write wishes of how they want the trust to be run. And this is taken into consideration by the trustees, who we'll move on to next. The trustees have the most important role in the trust because they are the people that operate the trust. They are the legal owners of the trust property, and they have legal duties to the beneficiaries to manage the trust legally and for the benefit of the beneficiaries. They are also guided by the wishes of the settlor when they set up the trust as to how they want the trust to be operated and who they want to benefit and how. The trustees have legal duties, and this is set out in law, and it's a very serious job to be a trustee and must be taken very seriously. Often people will have a trustee who is not a beneficiary. That may be a lawyer or an accountant or other trusted advisor who is there to give advice and be a trustee, but not be involved financially in terms of benefit from the trust. Trustees, most of the time, trust deeds will require trustees to make decisions all together. Everyone must agree before anything happens. An independent trustee can be involved to help make sure the right decisions are made within the requirements of the law, and so that no decisions are made which could cause harm to the beneficiaries, such as selling a property for undervalue or taking on risky ventures. The third player in the trust triangle, if you like, is the beneficiary. These are the people who benefit from the trust and the reason why it was set up in the first place. If you like, they're shareholders in the trust, to use a company term. The beneficiaries are stakeholders, and they are the people that receive benefit from the trust as determined by the trustees. There are two types of beneficiaries. Firstly, there's discretionary beneficiaries, and secondly, final beneficiaries. Discretionary beneficiaries are people that can benefit from the trust from time to time. They have no right to demand anything, but they do have a right or an expectation or hope to receive something at some time, but they don't know what or when. It's at the discretion of the trustees. The other type of beneficiary, the final beneficiary, is the beneficiary who will definitely receive something when the trust is wound up, provided there is something left in the trust. Discretionary beneficiaries may also be final beneficiaries, and vice versa. Sometimes the discretionary beneficiaries will be mum and dad, who are the settlors, their children, and the final beneficiaries may be children and grandchildren of the settlors. Another key part of the family trust is called the power of appointment. This is a bit like who is the boss of the trust. The power of appointment is basically the power to hire and fire trustees. Normally the settlor holds this power, and it's a very important power because it effectively controls who decides what happens to the trust. Normally this power has to be exercised for a good purpose. You can't just fire a trustee because you don't like them. There has to be a good reason to remove them. The only way to work out that question is to look carefully at the trust deed to see what the clause says in terms of the power of appointment. So by now, hopefully we have some idea of what a trust is, but perhaps if we give some examples about how they work, we can bring all of these strands and together in terms of all the players involved. And we can do that by asking the question, who should bother with having a trust? Well, the first people that we would suggest or recommend have a trust or look at having a trust are people who own a business and who want protection from their creditors. If someone is running a business and they're operating in their personal capacity, then they are subject to the risks from creditors in terms of their personal assets. So if they sign a lease for, say, a restaurant that they're operating, mum and dad have started a business and they're operating a restaurant, if mum and dad sign the lease and they guarantee payment of the rent, and then the business runs into trouble, then mum and dad could have creditors chasing, the landlord could be chasing their personal assets, i.e. their family home and cash in their own bank accounts. So they're left wide open and exposed to the risks from creditors in doing business and the uncertainties of the market. What a trust would do is to shield your personal assets from creditors. So if you're in business, what you could do is have a trust that owns your home and possibly has a bank account and any other private assets that you don't want touched by anyone in terms of were you to get into trouble. This must be set up when you are solvent and can pay your debts. And we would recommend that if you are considering a business, that you speak to your lawyer, accountant and trusted advisors as to whether you need a trust and set it up when you start a business or before you start a business so that it gives you the full protection. If you run into troubles and then set up a trust, this can create problems because you could be deemed to be hiding assets when you should be using them to pay your debts. In the case of our example of mum and dad that are owning a restaurant, they may decide to have another trust, a business trust. This trust would own the business assets. And if they were running a company, for example, that runs the restaurant business, the trust could own the majority shares in that company. When the business earns income, that money can be paid through to the trust of which the company is a beneficiary. In this way, the income streams can be protected from creditors. In all cases, we strongly recommend that you consider careful accounting advice and tax planning before you implement these structures so that your lawyer and accountant are working on the same page. It is very important to get structures correct, as the tax benefits of trusts are now somewhat diminished. With the introduction of the minor beneficiary rules, it is not as easy to direct income streams to minor beneficiaries, to take example of lower tax rates. Trusts are a very common tool to protect yourselves from creditors when you're in business. There are some other people that may want to consider having a trust, and we'll look at those now. Other people that want to have a trust may include those people with assets that they need to store somewhere. People who are asset rich, who have properties or other valuable assets, may wish to settle a trust to hold these assets in safekeeping for the benefit of their family and future generations. This has the benefit of ensuring that the assets stay within the family and are dealt with and used in a way that you would prefer. Trusts can operate for currently 80 years, and with a law change that's coming up next year, trusts will be able to run for 125 years. This means that the trust can continue for that long, even after the settlors have passed away. They can still have control of those assets through their memorandum of wishes, which the trustees should be following or considering. So trusts have a very good function for asset planning and succession planning. When a settlor passes away and they have put their assets into a trust, it means that they do not have a personal estate, and so there is no need to get probate of their will because there is nothing in their personal name of value. And so this reduces the cost of getting probate, and it also reduces the possibility of a claim against the person's estate because there's nothing to claim from. Their children are beneficiaries of the trust, but cannot claim against the personal estate of their parents because there is no assets in their name. It's all in the trust. This also can prevent claims from under the Testamentary Promises Act, as well as the Family Protection Act, in terms of promises made and legal duties to children. With a trust, that risk is virtually gone. I think we've jumped ahead a slide. Is it possible to go back, Connie?
Yeah.
Ah, thanks. Another reason for a trust is for people with family who have special requirements, for example, disabled children, people with intellectual disabilities or addiction problems, or people who are not good at managing money. If you have a trust and you have children who may need the protection of a trust, you can ensure that your trustees provide assistance to your children on an as-needed basis rather than giving them lump sums of money. The trustees could be instructed to only provide a certain amount of money to a child as and when required and when they demonstrate that need, rather than giving it to them all at once and wasting it. A trust can help protect families to stay together and to look after the most vulnerable. It can provide lifetime support throughout the person's lifetime. Another purpose for a trust can be to help protect separate property when you are in a de facto relationship. If you are entering a de facto relationship, it is possible to put property that you have into a trust to help you give some protection in the event that the relationship falls apart and a claim is made against the relationship property. We do not recommend this as a standalone feature for trusts. What we do strongly recommend is that if you have a trust and you are in a relationship, that you also enter into a contracting out agreement between you and your partner or husband or wife to ensure that what is separate property remains separate property, including any property that you have in trust. A trust will not on its own protect you from a claim by an ex-spouse or ex-partner from it being included as relationship property rather than separate property. Also, if you are coming out of a relationship property settlement and you have assets from a separation, it may be possible to settle a trust to protect those assets in the event that you enter a new relationship. And that can help to ensure those assets are used for the benefit of you and your children. However, again, if you enter into a relationship, the strong recommendation is a contracting out agreement to provide you with full care and protection. Both you and your partner would need independent legal advice from different lawyers in order for that agreement to be effective. The last reason I put there is actually a reason not to have a trust, because regulations have changed. Trusts move slowly as opposed to companies that can move quickly. And by that I mean that trusts are forced to change when they've been relying on rules for a very long time, such as the residential care subsidy. For almost 30 years, trusts were settled in order for people to gift money away into a trust steadily year by year, so that when they came to be elderly and needing residential care in a rest home, they could say that they had no assets and qualify for a residential care subsidy. Now, this is no longer the case, and generally speaking, if you have a trust, it will not protect you from avoiding having to pay for your own care. The Ministry of Social Development now is empowered, following a recent court case and a change in their regulations, to look at your trust to see what it owns and whether you have correctly gifted the right amounts to qualify or not. We recommend that this is not a reason to settle a trust on its own. However, if you have had a trust for a long time and have been gifting, it may be possible to still take advantage of the gifting rules. But we strongly recommend that you look at this and ensure that a lawyer is examining the deeds of gift to make sure that the correct gifts have been made within the permissible limits. For people that are starting out with a trust or have had a trust only for the last few years, it is not possible now to use that to qualify for residential care subsidy. The expectation is now that the trust be used for your benefit to help pay for your care. If I could just go back one step, and I wanted to talk about, sorry, Connie.
Sorry.
Just in regards to separate property, even if you have a trust and you and your partner are living in the home which is in your trust, it still won't provide you protection because your partner can say that they have made contributions to the trust property or have otherwise assisted you with the property, and that way they can claim an interest in it, even if it's in a trust. So again, the requirement is that you should strongly consider a contracting out agreement if you are in a de facto relationship and have a trust. So by now, hopefully we have some idea of what a trust is and how they can work. And you can see what I mean when we say it's kind of quite hard to understand what a trust is. You can't put your finger on it. You can't look it up like it is a company. It's on a piece of paper, and you can't exactly draw a picture of it. It's not there. But what you can do is ensure that you maintain a trust. Trusts need to be looked after in order to work properly. It's a little bit like having a pet dog or a pet cat. Particularly with a dog, you have to take it for a walk, you have to feed it, you have to give it water, and you have to look after it. It's the same with a trust. It's not a case of buying a trust, setting it up, and then letting it sit in the lawyer's office and forget about it. You can't sit and forget a trust. You have to maintain it. And by that I mean ensuring that the trustees meet together to decide how the trust operates. And they do that by recording trustee resolutions. Any major or significant decision that the trustees make should be recorded in writing in a resolution so that there's a record of what the decision was, not necessarily the reasons, but a record of what the decision was, and to show that if there is any query into the trustees' activities, they can say that they have made resolutions and here is the record of what they've decided. Key important decisions could be whether to buy or sell a property, or to enter into an investment, or to distribute money to a beneficiary. All of these need to be recorded in some form, not in complete detail, but just a simple record at the very least. Even if there's been no activity for a trust, if it's a very inactive or quiet trust, there should at least be simple annual resolutions saying that the trustees have looked at the trust deed, considered the needs of the beneficiaries, and decided that no action will be taken. This is very important. Otherwise, it could be said that there's no trust involved and that it's just the assets of the settlors. I mentioned the role of independent trustees, and this is a service that many lawyers and accountants will offer. And we strongly recommend that you consider having an independent trustee. Very often we see trusts that have the settlors of Jenny and Joe, the trustees are Jenny and Joe, and the beneficiaries are Jenny, Joe, and their 2 children. Can you say that there's really a trust involved? That's my question. Arguably there is a trust because it's been written down and it meets the legal requirements. But if there's a business involved, or if there's beneficiaries who are not happy, and Jenny and Joe are treating the assets as their own, forgetting about the trust, then where is the trust? An independent trustee can help you strengthen your trust and make sure that it is robust. An independent trustee is not a beneficiary. They're just a trustee, so they're impartial, and they give you, or they are there to give you honest, competent advice as to good decisions that the trustees should make and provide a sounding board for decisions. As I mentioned earlier, most trust deeds require unanimous decision making. So all trustees, including the independent trustee, must be involved. It is also possible under many trust deeds to have an advisory trustee. Sometimes they're not a trustee, but are thus just there to give advice, and the trustees must consult with them. And this is where we come back to the concept of a trust. It really is about trusting the trustees. Do you have trustworthy trustees? You want to ensure that you are fulfilling your duties as a trustee, and that you have an independent trustee who you are comfortable with and who you believe has your best interests at heart. Independent trustees are not there to make a problem for you or stop you making decisions, but are there to give honest advice and to ensure the trust is operated in the best interests of the beneficiaries. This is the legal duty of the trustees. When you have an independent trustee, generally they will charge a fee for that service. It may be between $350 per annum or $600 or $700 per annum, depending on what they are doing. Normally this will include an annual resolution and advice as required, which will be circulated amongst the trustees, and the annual resolution is signed, recording any decisions that are made and what has happened. The trustees annually, they should at least meet once a year to show that they have been considering the needs of the beneficiaries, either in person or remotely. Trusts may be slow-moving and hard to define, but they are very flexible, and they can be used to meet any requirements for families. There is, of course, some risk with having a trust. As I said, if you don't have an independent trustee or you're treating the assets as your own assets, the question is, you don't have a trust and you lose the protection, for example, from creditors, or protection from beneficiaries who think there is no trust and demand their assets now, or other risks that you wouldn't expect. All of this can be mitigated by ensuring that the trust is well maintained and operating smoothly, with all the trustees on the same page. I've already touched on the importance of a competent advisor, and some people feel that this is likely to hold up their trust, be an unnecessary expense, or be too difficult for them. But again, our strong recommendation is, if you've decided that you need a trust, you should also agree that it needs to be run properly and have good advice available to the trustees so that the trust continues and serves your needs and purpose. Otherwise, you have to ask, why have I got a trust in the first place? So we've talked about a lot of the benefits of trust and what's involved and how it can help you. But of course, there are some drawbacks to a trust, some pitfalls that are easy to forget. The first and most important one is that you no longer have assets of your own. As soon as you give assets to a trust, they become the assets of the trust and are held in the hands of the trustees. If you own an asset personally, you can do whatever you like with it. You can sell it for whatever price you want. You can use it however you want, and you have no obligation to account to anyone. If it's in a trust, you can't do that. All the trustees have to treat the asset for the benefit of the beneficiaries and agree on how they will do that. So there is a significant loss of control of your assets if they're in trust. They're no longer yours. We see this if a trust has a bank account and one of the trustees, say mum or dad or the settlors, are using the trust like it's their personal account. This is not to be recommended, and if that is their preference, then the trustees should all agree to enter a resolution that says that Joe and Jenny have permission to access the trust bank account as required for their set purposes. And so there's a general resolution allowing for that to happen at the very least. If there's no resolution, then arguably that's a breach of trust. The other pitfall is that potentially you're risking having your assets run by other people and requiring everyone to agree on how those assets are dealt with. So the assets are held in the hands of the trustees, and so you must be prepared to give up control and trust that your trustees will do the right job. There are administration costs, which I touched on earlier, These are fairly minor, although do be aware that with trusts there is generally more paperwork involved if there is a refinance or a property purchase or opening a share portfolio or transferring a life insurance policy. There is more paperwork involved. There are trustee resolutions to complete, and all of the trustees must sign the paperwork in order for it to be effective. So having your trustees available to sign quickly is beneficial. Lastly, there is a risk that beneficiaries may be unhappy and challenge the trustees as to their actions, and often they will say, "Why haven't you given me any money?" And that can be a real concern for some trustees, where there is money in the account and it's just been sitting there and nothing has been happening. Have you actually considered the needs of the beneficiaries? And if there are challenges, then you need to respond to those challenges. Otherwise, the beneficiaries are entitled to go to court and request a review of the trust at the High Court. Beneficiaries as I said, are the stakeholders in the trust, and they are entitled to have assets administered for their benefit. That is their legal right. The question is, how does that happen? And that is the question for the trustees to answer. There is a new law coming through which we will touch on very briefly in terms of challenges from beneficiaries, which is making this a possibly significant concern for some trusts. Just on the topic of administration costs, before I move across to the next slide, if the trust is earning income, it will obviously need an IRD number, and it will need to file an annual return. So these are also some administration costs and accounting costs which you need to take into account, which you may not otherwise have to bear if you were owning the assets personally. So there is an accounting cost as well to consider. The final slide.
Yes, I mean, this is the last one.
Ah, yes. So by way of conclusion, I've hoped to have walked around the idea of a trust and what's involved and what trusts do and what the pitfalls are. What we have decided to do in a future webinar in the next couple of weeks is to look at a new law coming into effect early next year, which is called the Trustee Act 2009, and it brings about quite a few significant changes which anybody with a trust will need to be aware of. And at Turner Hopkins, we are currently talking with a lot of our trust clients about how to respond to this new law. And it's important for trustees and anybody in particular who is looking at a trust in the current uncertainty with the economy and COVID-19 to really think about what their trust is doing, if they've got one, and whether they need a trust, and to think long term. I'm talking 10-year cycles, because trusts, as I said, live for a long time, or they can live for a long time until they're wound up. And the question is it going to benefit me, and how? And should I keep one for the long term in regards to the new law? There are now obligations to give information to beneficiaries and higher trustee duties. So having a trust is now a very important question. Or another important question is, should I not have a trust? Because the law is changing and we are dealing with having to consider winding up trusts or changing trusts to ensure that they are effective under the new law and protect the trustees and the beneficiaries. That's another topic for another day, and we look forward to perhaps you joining us to talk more about that. But perhaps if I hand back to Connie for any questions you may have.
Yes, thank you, Samuel. That's really insightful information. That's great. And as Samuel said, we're going to run another session in a couple of weeks. Otherwise, it's just too overwhelming, especially if people has no knowledge about the trust. There will be too much. So there will be another kind of add-on session. We'll go into in depth about some of the changes, as Samuel mentioned. So yeah, we look forward to getting you back for another session. So now let's go to the Q&A. We do have some questions here. So, all right, let's deal with the first one. So if we want to put our property into our trust, do we need to get consent from our bank? Will they consent to it?
Normally the bank will consent if there's obviously there's a mortgage, and depending on the bank, normally the bank will simply consent to the change in title, so from your names to the names of the trustees, and then the mortgage is re-registered. So banks won't have a problem generally giving consent. In some cases, however, they may require new loan documents to be issued, either in the names of the settlors, yourselves, or in the names of the trustees. And there will also usually be a personal guarantee required from the settlors or the trust, depending on what the bank requires. But the bank consent shouldn't be an issue.
Right, Sammy, just add on to that. For the loan to be redocumented, bank do need to look into the income of the trustee. So in order to change the borrower as well, they need to reassess the servicing, the loan affordability as well. Yeah, cool. Good. Next question, do I have to make distribution to all beneficiaries instead of distributing to only one or two beneficiaries?
If they're discretionary beneficiaries, then it's up to the trustees who they distribute to. So it can be everyone or one person or no one. It's up to the trustees. And of course, depends what the distribution is. But they're discretionary. They only have a hope or expectation of some reward. So it can be any number of trustees, any number of beneficiaries, sorry.
Great, thank you. The next question,
sorry, Connie.
Yes, sure.
It occurred to me for the last part of that response is that if it's only going to be to one discretionary beneficiary, the question is, why not the other discretionary beneficiaries? And that's, of course, a question of context. And the trustees don't necessarily have to justify their decision to the beneficiaries, but they need to be able to justify it to themselves and have reasons as to why they gave money or distributions to one beneficiary and not all of them, or not another beneficiary in the same class, for instance.
Great, thank you, Sammy. Cheers. Next question, why if we can't locate the original full set of our trust records, will that causing any problem later on?
It's a good question, and if the trust documents are no longer available, the question is there still a trust? And arguably there is, but it's difficult to prove it. And if all efforts are made and you still can't find the trust, then you've got a bit of a problem, depending on what the trust owns. If it only owns the family home and the trustees are simply Jenny and Joe, or mum and dad, then it may be possible to simply transfer it out of their names as trustees and into their names as joint tenants, for example, and effectively record a deed winding up the trust, recording that the deed can't be found, but that it was signed presumably on such and such a date, and wind up the trust. But obviously it's important with trusts to have good record keeping, as I've touched on, so that this doesn't happen. Hopefully the documents are normally stored in a lawyer's office for safekeeping, so that everything is clearly documented.
Great, thank you, Samuel. I have a question here. I think you already covered in your presentation how important it is to have an independent trustee. Yeah, I think you mentioned that, but do you mind just give you a quick answer about the importance?
I guess the importance is basically to avoid any claim that the trust is a sham, i.e. it's just your assets, there's no trust. If there's an independent trustee, and often that will be a company that's set up for the sole purpose of being a trustee, which will be on the company's website, then there's strong evidence that there is an independent trustee and that the trust is a strong, legitimate trust. So it's a protection mechanism. Otherwise, there's no difference from property held personally and property held by the trustees. Trustees hold property personally. And so if you look up title records, for example, or look at a bank account, it may just have the people's names. But if you can see their names and an independent trustee, you know that it's a very strong trust, for example.
Thank you, Samuel. People ask who should be involved when setting up a trust. Is that accountant or solicitor? Because we've been talking about, both professional are important. Make sure trust is set up well. So
yeah, obviously, my view would be that the lawyer is involved with setting up the trust, and the accountant is involved in ensuring that any tax obligations or financial requirements are adhered to once the trust is set up, and both advisors should work together with the client, and we do that very often. We do have trusts that are set up by accountants, and that's not necessarily a problem, but as I've tried to demonstrate, trusts are quite difficult to understand sometimes, and often you do come across errors in trust documents, not always by accountants, but I have seen one or two trust deeds where the settlor is the accountant, and which is okay, but then the final beneficiaries are the settlor's children, and yet that is completely incorrect, and there's no ability to change the trust deed as well. It's important to have an up-to-date modern trust deed which lawyers will be holding and able to adopt to the requirements. You shouldn't just use any old trust deed, because you can have mistakes that can't be fixed or buried, and you can run into very serious problems.
Great, thank you, Samuel. The next question is, how do I transfer property to a trust? Should I gift it or sell the assets with the debt back to me? So that's about remaining equity.
Yeah, that's a good question. It's best nowadays just to gift the assets to the trust. Gift duty was abolished, I think, in 2015 or thereabouts, so quite some time ago. So there's no duty in terms of tax payable for gifted assets. It's much simpler to gift it across. The alternative is to sell it to the trustees for a market value, and then they owe you the debt back, and then they steadily gift that off. That's a bit more cumbersome in terms of paperwork, and probably redundant now that there's no gift duty, which was the whole primary reason behind that. So gifting by a simple deed of gift is okay and common and recommended now. The only advantage with the debt back scenario and selling it and debting it back to you, the settlor, is that that asset is a debt which you can call upon. So the trustees will be obliged to pay you back, i.e. sell the trust property and pay you back. So that can be useful if you want to retain some control over that asset and call it back. And that should be recorded in a deed of acknowledgement of debt, which still happens. But obviously any transfer, however it happens, should be done at market value, and you should attach a valuation of the property or the asset and attach that to the deed of gift so that it's legitimate for tax purposes.
Great, thank you, Samuel. We got a lot of questions. So yeah, it's a really popular topic. So people ask, after we set up a trust, do we need to have a new will drafted?
That's a very good question, and yes, you do. When you have a trust, normally you will say that when I pass away, I want everything that I have left over to go to the trust, and so usually you would do a will that sets that out, and provided the trust is still in existence, so it's sensible to do a will as well, and that is part of our estate planning when we assist clients with a trust, is that we look at their will and do a new one, and also look at, for example, powers of attorney.
Great. People ask, how much do you charge annually for independent trustee services?
For independent trustee services, Turner Hopkins currently charges $350 plus GST and disbursements, so that's just over $400 per year, and that is includes the benefit of one of our trustee companies as your trustee, and general administrative attendances, and any basic advice. You can call me up and I won't be charging for my time to answer any questions of a simple nature. Obviously any instructions is in addition to that, but that fee covers general attendances and an independent trustee service and annual resolutions.
Great, thank you. Next question, can you talk more about in what situation that a trust can be seen as a sham trust and invalid? Can you give me an example?
Well, the classic example is Joe and Jenny as settlors and trustees and beneficiaries. So basically, it's still Joe and Jane. There's no independent third party exercising the trust for the beneficiaries. That would be an example potentially of a sham. I'm not saying it is, because there is a trust deed creating the trust, but the question is, are the trusts actually operative, which is a legal question, but a sham would be that kind of situation where it's effectively personal ownership still.
Yeah, excellent. Next question. I have separated from my ex-husband and I'm looking after my children. Should I create a trust to protect my assets for my children now?
That's a good question, and it depends on what the client would feel comfortable with and also how many assets are involved. If there's a large sum of money and some properties left over in the settlement, then it may be a good idea to have those assets in trust to protect them for any future relationship, and also to ensure that the children are included as beneficiaries and will benefit from that property or replacement property. Alternatively, the answer could be not at this stage, but consider when you enter into a relationship whether you want to have a trust for that purpose as well as your contracting out agreement.
Excellent. Thank you, Samuel. Got three questions to go. This is to do with the tax. So if a company shares are held by the trust, in terms of tax, will the company be charged based on company tax or trust tax rates? Is it something for you to answer, or is it really a tax accountant question?
Probably more of a tax question. I mean, the trustee tax rate is 33%, which I think is the same as the company rate. So there's really probably no tax benefit from a percentage point of view. The benefit, I suppose, comes with trusts is if you're able to tax it at a beneficiary's tax rate, and there is now only limited circumstances in which that can happen. But I can't really answer that question with confidence, I'm afraid.
Sure. Yeah, it's best to ask a tax accountant for that advice. Yeah. Okay, so two more. If you are a beneficiary, can you use trust property to buy property for yourself, or does the new property has to be under the trust name?
If you're a beneficiary, well, obviously you can buy whatever property you like, regardless of whether you're a beneficiary, but you could also be a settlor of the trust if you wanted to by gifting property to the trust, but then that would fall into the hands of the trustees, and they would consider how that property or asset is used for the benefit of the discretionary beneficiaries, which may include you, but may include other people. So you could still do that. The question is why.
Yeah, I guess there are also some implication. For example, they use the trust assets as a security to buy, say, a rental. They'll depends on how it's structured. It could, expose to kind of guarantee risk because obviously use trust assets. I think it's case by case, but you can use the property as security if you want to.
Yes.
Get a mortgage.
Yeah.
Cool. Okay. Last question. How do I know if my property has been transferred to my trust if I can't recall whether it's done or not? Any way to check on what trustee owns? So is it
Yes.
record?
I guess the first question was to talk with your solicitor if you have a solicitor, and they will be able to tell you and send you a copy of the property title, which will show the names of the trustees. That's probably the only way to do it. So you'd need to look at the property title and get a copy to see that.
Yeah. Excellent. Thank you so much. I think, we answered all the questions, Samuel. That's really well done, and we are within the time frame, so that's great. The biggest tick out for me is I have a trust myself, so I know most of the things about what you mentioned about the if someone in a de facto relationship, it's also recommended to have a contract out agreement, even though you already have a trust for a beneficiary. So that's really, like light bulb moment for me. So thank you so much, Samuel. I think, we don't have any more questions. So again, thank you so much, Samuel. You provide a lot of useful information and then give the audience an overview about the trust and, what the trust is about, what it's made up of, what is the common pitfall, etc. So that's really helpful. And we're looking forward to have you back in a couple of weeks and just talk about the changes Just before you go, Samuel, can you let people know how to get in touch with you if they want to get your professional service?
Sure, thank you. Well, I'm available on the Turner Hopkins website. You'll see my email address and mobile phone number, and we're at turnerhopkins.co.nz. I should have included my contact details on the slides, but my email address, if you have a pen, is samuel.ames, A-M-E-S, at turnerhopkins.co.nz. And my mobile number, which you can reach me on at the moment, is 021 236 4452.
Yeah, and we'll also send out the recording once it's available and attach your email and phone number to the audience as well, just in case.
Thank you.
Great. Thank you so much, everyone, for your time. And I hope you'll get some value from this seminar. And if you want to keep up to date in terms of what the changes are coming up, then please stay in tune and join us for the next session in a couple of weeks. Thank you again. We'll see you very soon. Bye-bye. Bye, Sammy. Thank you.
Bye-bye. Thank you, Connie.
Bye.